Okay, hi everyone, and thank you for being here for our webinar. This is Top 3 Privacy Concerns for Digital Health Innovators. My name is Caitlin O'Connor. I am Senior Counsel with Nixon Gwilt. I'm just going to introduce our panelists and the webinar and then let them take over. But first, I did want to tell you a little bit about the webinar and our firm, and then I will hand it over. So just as a quick reminder, we are lawyers, so we have to get the boring legal stuff out of the way at the beginning. This webinar presentation is designed to be informational only. It is not legal advice. Just because you're attending does not mean you become our client. However, we would be happy for you to become our clients if you so choose. But so just keep in mind that you should not rely on any of the information in this webinar as actual legal advice. And if you have any deeper questions or need actual legal advice related to data privacy, please reach out to an attorney for that. If you are not familiar with Nixon Gwilt, I will just tell you a little bit of background about the firm. Nixon Gwilt is a healthcare innovation law firm. We are focused only on the rapidly changing environment that is healthcare innovation. We typically work with 3 buckets of clients, from innovative healthcare providers to digital health vendors like software companies and some device manufacturers. And then we also have clients on the life sciences side as well. That's where we've got some of our pharmaceutical clients, our more advanced software clients that fall within FDA regulatory, with the FDA regulatory landscape. Yeah, so those are our 3 clients. As you probably know, in the healthcare innovation world, there is lots of overlap between those 3 buckets. And we like to work within those exciting overlapping areas. So the 2 attorneys you're going to hear from today are absolute experts in the privacy landscape that is related to healthcare. However, they've also got lots of general healthcare experience as well, and they'll talk to you a little bit about that. If you're interested in the firm or in the panelists today, please feel free to reach out to them. Their contact information will be included in the, Bethany, is it on the first slide or is it on the last slide?
Yeah, so we have it on both. We have it on both of the bio slides and then at the end as well.
Perfect. Okay, so feel free to reach out via email if you are interested. We love to have follow-up conversations and talk deeper about the issues we're about to discuss. Lastly, before I hand it off, I will just let you know, because people always ask, we will not be handing out the slides after the presentation, but we will be recording this webinar, and the recording will be available to everyone who registered, and then we'll also host it on our website. So if you or someone you know wanted to be here and isn't able to watch live, fear not, you will have access to the recording afterwards. Of course, if you have questions, feel free to drop them in the Q&A. We'll answer them at the end. And without further ado, I'm going to hand this over to Bethany and Ashley, our panelists for today.
Wonderful. Thank you so much, Caitlin. And just to echo the sentiments, we're very thankful that you're here with us today. So I'm a healthcare innovation and privacy attorney at Nixon Gwilt, focusing on the intersection of healthcare and technology. I have a healthcare LLM with a certificate in compliance studies from Loyola University of Chicago. And I'm also a certified information privacy professional, CIP US. In addition, I'm certified in healthcare privacy compliance, and I'm the co-editor of the upcoming AHLA book, Healthcare Contracts, a clause-by-clause guide to drafting and negotiation. And as Caitlin mentioned, I've included a link here to the bio and also my contact information. So please feel free to reach out if you have any questions. And I'll now turn it over to Ashley to introduce herself.
Hello, everyone. I'm Ashley Giovannini. I'm also a healthcare innovation attorney here at Nixon Gwilt Law. I have a health law LLM as well from St. Louis University in St. Louis. And much of my practice focuses on digital healthcare platforms and addressing their data privacy and security needs, as well as helping them set up their business formation. I also will be authoring an article in an upcoming textbook with the Mayo Clinic, and that should be releasing in 2022 on the FDA regulation of artificial intelligence and machine learning.
That's fascinating, Ashley. I'm really looking forward to reading that myself. So today we're really going to focus on 3 privacy concerns that we regularly encounter for digital health innovators. The first privacy concern we're going to look at is HIPAA, and particularly looking at how you know if HIPAA applies to your organization, and if HIPAA does not apply, what the rationale might be to actually comply with HIPAA anyway. Then we'll turn to a brief discussion about some of the new developments we've seen in state privacy laws, including some of the new enforcement priorities that may actually impact your business. The third concern that we'll address then is GDPR considerations for digital health companies that access EU resident data. And then finally, we'll look at how you can develop privacy documentation, including privacy policies, notices, and procedures based on your specific business model and your goals that can actually help you secure deals faster and mitigate privacy risks. And as we're going through the presentation, if you have any questions, as Caitlin mentioned, please go ahead and drop them in the Q&A and we will answer them at the end. All right, next slide. So why does privacy matter? And before we dive into these top 3 privacy concerns, that's the question I want to take a minute to answer, because a lot of times, most companies that are in the digital health space are aware that there are privacy obligations that accompany their use of patient data, especially if that data is identifiable or sensitive. But a lot of times, privacy itself gets reduced to a risk mitigation function. So if you ask companies why they think they need to include privacy protections for the data that they collect, usually what I hear is some version of this answer. It's legally required and I need to do the minimum to comply so that I don't get investigated or sued if a data breach occurs. So in other words, what I'm saying here is that I see a lot of privacy compliance being used as risk mitigation. And while privacy compliance absolutely can and should be used for risk mitigation, that's not the only function of privacy. And indeed, I can tell you that privacy as a risk mitigation tool doesn't usually crack the top 20 concerns that our digital health startup companies have on their list. And what I want to convey here is really that privacy compliance can actually be much more beneficial to an innovation company beyond risk mitigation. So specifically, we counsel clients that they can use privacy compliance to help close deals faster and secure high-level industry partnerships faster. And the reason for this is that venture capitalists, investors, and industry partners really want to contract with companies that safeguard patient data to the fullest extent of the law. So they don't want to have a weak link in their vendor chain that might expose them to privacy lawsuits or investigations. And we've typically seen a number of deals get held up at the due diligence stage because that company hasn't invested in the proper privacy infrastructure to contract with that vendor or that investment partner and take their business to the next level. So building a solid infrastructure for privacy is really necessary so that you can secure higher level deals faster. And those can actually take months if you haven't laid the groundwork, and it can actually derail deals if you don't have the right privacy structure in place. So while you may not have thought of privacy beyond risk mitigation, I really want to encourage you to see its value in helping you achieve your next set of business objectives. And if you need help figuring out how privacy can fit into that business structure, that's what we're here for. Next slide. So with that framework in mind, I want to talk first about the common privacy compliance questions we get with respect to HIPAA. The main question our digital health innovators have is, does HIPAA apply to my digital health organization? And if not, is there really any value in me being HIPAA compliant? Most digital health companies, and a lot of patients for that matter, actually assume that HIPAA applies to all types of healthcare data. And that's actually an incorrect assumption. So Congress passed HIPAA back in the 1960s to reduce the administrative costs and burdens that were associated with healthcare delivery. And neither of those goals were actually directed at privacy. And instead, the privacy rule that resulted from HIPAA was not substantively discussed in the HIPAA statute. Instead, when Congress failed to create a privacy law, the Department of Health and Human Services created federal regulatory protections for the privacy of certain health information that was collected in certain settings and that was held by certain entities. And this is then what's known as the HIPAA privacy rule. And the HIPAA privacy rule sets forth the limitations on the use and disclosure of protected health information, which is commonly referred to as PHI. So while the scope of the HIPAA privacy rule appears at first blush to be pretty broad, it's actually limited to healthcare organizations that qualify as covered entities. So what is a covered entity then? A covered entity is any health plan, healthcare provider, or healthcare clearinghouse, as those terms are statutorily defined. And in 2009, the Health Information Technology for Economic and Clinical Health Act, which you've probably heard as the HITECH Act, expanded HIPAA's provisions to business associates. And business associates really include persons or organizations that perform certain functions on behalf of a covered entity that's using or disclosing PHI. And the foundational principle of the HIPAA privacy rule is that a covered entity or a business associate cannot use or disclose PHI except as either expressly permitted in the privacy rule or as otherwise authorized by the patient in writing. And this also means that the HIPAA privacy rule is only governing protected health information, not all health information. Next slide, please. So this then brings us to the question, does HIPAA apply to a digital health company? The answer to this is usually going to be no, and there's three key questions that you're going to need to ask to try to make this determination. The first question is, are you a covered entity? In other words, are you a health plan, a healthcare provider, or a healthcare clearinghouse? And most of the time, a digital health company is not going to fall under any of these categories because they aren't providing health insurance. They're not a physician or other licensed healthcare provider, and they aren't a third-party system that's interpreting claims data between provider systems and insurance payers. So for example, if you have a company that has created a femtech app that's using an algorithm to predict ovulation, you're likely not going to be a covered entity under HIPAA because you're not a healthcare provider, you're not working with a healthcare provider, you're not a health plan, and you're not a healthcare clearinghouse. Now, where we generally see a digital health company qualifying as a covered entity is in the following circumstance. The digital health company builds an app or a device that is used to send data to a healthcare provider. That healthcare provider is then using that data, interpreting it, analyzing it, and sending results or analyses back through the app to the patient. And that's the app's or the device's primary function. So in that situation, because of the integral connection between the healthcare provider and the digital health product, HIPAA could be triggered. Now, if you answer yes to this covered entity question, you don't need to proceed to the second question. You do still need to look at the third question. If you answer no to the covered entity question, you're not out of the woods yet. You've still got to make sure that you're not qualifying as a business associate. So that brings us to the second question, and this is whether or not you're operating in a business associate capacity. So a business associate is a person or entity, as I mentioned before, that's performing activities involving the use of protected health information on behalf of or providing services to a covered entity. So in other words, right, a business associate is kind of like a contractor of a covered entity that's using PHI. So ask yourself, are you contracted with a health plan, a healthcare provider, or a healthcare clearinghouse? If so, do you have a business associate agreement with that entity that's flowing down HIPAA contractual requirements? Most digital health companies are not going to qualify as a business associate at this stage, especially if they're in the startup stages, because they don't have a lot of those contracts in place yet. They're not working with more established healthcare providers and health plans, and they're more in the early stages of development. So if you are not a covered entity and you're not a business associate, HIPAA does not apply to you. You don't even need to go to this third question. If you are a covered entity or a business associate, you then need to look at this third question. And the third question is, are you collecting, using, or otherwise recording protected health information? So HIPAA only protects and regulates PHI. And PHI refers to individually identifiable health information, and it includes demographic data, data that relates to the person's physical or mental health, data relating to the provision of healthcare services to that individual, and data relating to the payment for healthcare services or other data that's identifying the individual or providing a reasonable basis for that identification. Now, if the data has been de-identified in accordance with HIPAA's requirements, then that data does not qualify as PHI. But if you collect health data that satisfies this definition of PHI, and you're either a covered entity or a business associate, you have to comply with HIPAA. If you're not a covered entity or business associate, and you're not using PHI as one of those entities, HIPAA does not apply to you. So given these considerations, most of the time, HIPAA does not apply to our digital health innovators, especially startup companies. And what this actually means is that we have a gap in federal regulation for healthcare data privacy. Next slide, please. So that then leads us to the question, are there other ways HIPAA could apply to a digital health innovator? Now, the answer to that is yes. And that's where I want to caveat my above discussion about HIPAA applicability, because even if HIPAA does not statutorily apply to your company, you could actually be contractually bound to follow HIPAA. So for this reason, I like to stress to clients that it's crucial to analyze any type of vendor contracts that you have to make sure that you haven't signed something that says you're going to be contractually bound to follow HIPAA or that your organization is HIPAA compliant. If you sign a contract that says you're going to comply with HIPAA or that you're HIPAA compliant, you then need to follow HIPAA standards, even if HIPAA would not otherwise apply to you. So make sure that you're closely looking at your contracts, including the ones you currently have in place and any other contracts that come through the door in the future. Next slide. So even if HIPAA doesn't apply to you legally, maybe you haven't been contractually bound to follow HIPAA, it raises the next question of, should you comply with HIPAA? Should you engage in voluntary compliance? And it's interesting because you're probably sitting there wondering, why would a company want to comply with HIPAA, right? If we don't have to, why would we want to take on a somewhat large and potentially unnecessary compliance burden? So whether or not your organization chooses to voluntarily comply with HIPAA is going to depend on a few factors. And it's really going to be an individualized choice for each company. And as you're going through this analysis to try to determine whether or not you want to comply, I would really encourage you to think about a couple of considerations. So what are your immediate and long-term business goals? Who are you contracting with in the near future? If you're seeking an industry partnership or looking to close investment deals maybe within the next year or two, HIPAA compliance can really make the due diligence process run a lot more smoothly. And you'll actually be able to more quickly and efficiently answer questions about your privacy practices and procedures to those vendors. And some industry partners actually require that their vendors adhere to strict privacy guidelines, even if they aren't legally required to do so. And those strict privacy guidelines that they might require are often in alignment with federal and state law. So if you're going to contract with a well-known industry partner in the near future, you might want to go ahead and build this privacy structure because it's likely going to be required to help you secure these larger contracts. Conversely, if you're just setting up your business, you're just getting off the ground, your immediate concern might just be compliance with any applicable state laws while keeping more robust privacy enhancements for the future. The next consideration is, how do you want consumers to perceive your product? So consumers are becoming increasingly educated about privacy. And there's actually been an increase in the number of consumers who are selecting products based on how they're designed. Are they designed with privacy in mind? Do they have privacy enhancing technology? So if you're looking to appeal to this type of audience or you're trying to set yourself apart from competitors, you might think of becoming HIPAA compliant so that you can advertise your product in that way. The third consideration here is, what is your privacy budget? Right? We understand, especially in the startup phase of a company, that there's not much money that you can spend on privacy. So you're trying to launch a product, right? You've got to get a business off the ground, and it just might not be financially feasible to be fully HIPAA compliant right off the bat. And that's okay, right? Think about what type of privacy projects you want to prioritize at each stage in your company's development. And one way you can prioritize privacy projects is by conducting a gap analysis to try to see what are your high, medium, and low risk areas for privacy. And with your current funding, maybe you go ahead and you address those high privacy risks and you save medium or low risk privacy projects for the next round of funding. And that's actually what we'll talk about a little bit later in the webinar, is our unique digital health privacy exposure audit that we're really excited to share with you, and that might be helpful in helping you prioritize these risks. Next slide. So moving out of HIPAA compliance, the second privacy concern that we see a lot with digital health innovators is compliance with state privacy laws. Especially for clients that are operating in multiple states, trying to navigate and comply with these different privacy frameworks can be burdensome and time-consuming. And as I mentioned, most of our digital health companies are going to be falling between the gaps for federal privacy regulation. And because of this gap, we've really seen a lot of states swooping in to try to create state privacy laws that then govern healthcare data as a way to help bridge this gap. Now, from a patient perspective, a lot of times these laws are seen as protecting consumers and helping to safeguard their sensitive data. From the healthcare digital health innovation perspective, especially for newer startup companies, these laws can be seen as burdensome, and they can mean that you have to comply with a number of different standards, especially if you operate in all 50 states, because unfortunately, no state law is identical. So regardless of whether HIPAA applies, you have to comply with applicable state law. And to do this, you need to first determine what state law applies to your organization. And to answer this question, you need to look at where are you conducting business? Where are your consumers located? Where are you collecting data from? If you're collecting data from consumers across the US, you could be availing yourself to multiple states' privacy laws without necessarily knowing it. So looking at where your business operates, where your consumers are located, and where you're collecting data will really help to inform which laws are applicable to your organization. The other thing I want to stress here is that you have to comply with state law, even if you're complying with HIPAA. So HIPAA is seen as the floor of federal privacy protection. It is not the ceiling. And that means that HIPAA does not preempt more stringent state laws. So if a state law has more stringent privacy protections than HIPAA, and there's no exception to compliance if you're a HIPAA covered entity, then you're going to have to go ahead and comply with that state's law. Now, the final aspect that I want to address with respect to state privacy laws is the question, what is the future of state privacy laws? The answer to that is that state privacy laws are really here to stay, and states are actually increasing their regulation of health data and their enforcement actions for deceptive practices with respect to using that data. So, for example, Colorado and Virginia passed new state privacy legislation earlier this year. Privacy legislation is also pending in a number of other states. In California specifically, and I'm going to let Ashley jump in here as well, given her expertise on the CCPA, but we have the California Privacy Rights Act taking effect in 2023, and that's going to expand consumer rights with respect to accessing and controlling data. And there's also a new agency dedicated to privacy, which is the California Privacy Protection Agency, which is actually going to be responsible for handling privacy enforcement. So we're really expecting privacy enforcement to skyrocket in states over the next few years. And Ashley, I'd love for you to jump in and talk about CCPA here.
Of course, yes. And we do anticipate that the enforcement actions on the CCPA will skyrocket, as Bethany mentioned. I think it's important for us to note that the CCPA does not just apply to consumers that you are providing digital health solution services to. It also is going to apply to the people that you employ in California and what you do with their data. It has a number of requirements for privacy notices and privacy policies that you're required to maintain in case a data subject in California wishes to understand how you use, process, or share their information. We are also staying abreast of all of the new legislation as it comes in. But one thing that we have noticed is that a lot of the new privacy legislation across the country largely mimics some portions of the CCPA. Additionally, it's good to note for digital healthcare innovators that there is what is delineated as an exception for HIPAA covered entities in the CCPA, but that actually applies to the data and not the entity entirely. So even though you may be exempt from HIPAA on a very baseline level, you still have to comply with the rules for data that is not HIPAA PHI. And then, Caitlin, if you wouldn't mind switching to the next slide, I'm going to take it from here, Bethany, if you don't mind.
Fantastic. Thanks, Ashley.
Thank you for those wonderful points on HIPAA and state privacy law. So as the market for digital health solutions continues to rapidly develop, it's also critical for you to consider international laws that may have an impact on the data that you process as part of your app or your platform or your website. Specifically, we want to spend some time discussing Europe's General Data Protection Regulation, which you may know as the GDPR. Generally speaking, the GDPR was established to regulate the flow of personal data belonging to citizens of the EU in a uniform manner. That seems relatively simple, right? Well, as enforcement of the law has begun to pick up, we've noticed that there are some important considerations for digital health companies who have EU data subject users. Next slide, please. Before I jump in, I want to touch on the real purpose of the GDPR, which is protection of users. So EU data subjects have the right to control their information and how it's shared. At first glance, these rights are relatively straightforward. Data subjects have the right to access their data. They have the right to have their data transferred, have their data rectified. They have the right to object to processing. They have the right to have their data erased, and they have the right to restrict how you process their data. Now, I know what you're thinking. How am I, as a digital health innovator, supposed to manage these data rights for numerous EU data subjects? And how will that play out if I want to rapidly expand in the EU? You might also be thinking, well, we maintain medical records. Do I really have to delete data at a user's request? These are all really important questions, and they're also questions that could span an anthology of webinars. In any event, GDPR applicability is intensively data and business model specific. Today, we're hoping to set a baseline for you as a digital health company to understand where to set your priorities if you're currently or are considering a move into the European market. Next slide, please. To begin, I'd like to talk a little bit about to whom the GDPR applies. Broadly speaking, the GDPR applies to the data of persons who are citizens of the European Union and the European Economic Area. As you can see in the graphic, these are countries where the GDPR is applicable. This means that the GDPR applies to the processing of personal data in the context of activities conducted by an entity that is established in the EU, regardless of whether the processing actually takes place there. So to translate, if you're an established business in the EU, the GDPR is likely to apply. However, it doesn't stop there. The GDPR applies to the processing of personal data by controllers and processors not in the EU if they're offering goods or services to EU data subjects. This includes marketing to EU data subjects or allowing users from an EU or EEA country to participate in your app, platform, or website. And finally, the GDPR applies to the monitoring of data subject behavior that occurs within the EU. This is particularly important if you use cookies, as many EU countries are beginning to tighten restrictions on cookie usage. Now, this leaves a bit of ambiguity. What if your company interacts with an EU citizen on an isolated basis or even accidentally? What if an EU data subject lives in the United States and interacts with your app? Within such a narrow scope, you are likely not subject to GDPR compliance. However, if you consistently process the data of EU citizens or hold yourself out as doing business there, GDPR compliance is required. Next slide, please. Now, those of you who already interact with the data of EU data subjects, or possibly you're considering moving into that market, may be wondering how to determine whether your business qualifies as a data controller or a data processor. I've included the Article 4 definitions on this slide of a controller and processor. However, in reality, the data that you process and the functionality of your platform may render you both a controller and a processor simultaneously. If you're processing data directly obtained from the data subject, either with consent or based on another legal basis, you are likely a controller. If you're instead ingesting data from another entity with instructions on how to process or analyze that data, you're probably a processor. It's important to point out that your status as a processor or a controller can change your privacy obligations. In some, data processing relationships in the digital health realm can get very complex very quickly. And this complexity only continues to grow when you consider the interplay between the GDPR's regulations of various data types and additional member state rules pertaining to specific data. Next slide, please. So the GDPR regulates personal data, meaning information relating to an identified or an identifiable natural person. So what renders this data identifiable? Well, naturally, if someone can be identified directly or indirectly by something in the data, that is, considered identifiable. Article 4 of the GDPR specifically points to names, identification numbers, online identifiers like IP addresses, and factors specific to physical, physiological, and genetic identity as examples of identifiers. That's pretty broad. Now note, the GDPR does not regulate anonymized data. That is, data where all identifiers and possibility of identification of the data subject have been removed. However, make no mistake, anonymization under the GDPR is not the same as de-identification under HIPAA, as we are generally aware of. When we think of de-identification under HIPAA, we think of the expert determination and statutory safe harbor methods. Those rules are very clear about how to de-identify data in a HIPAA context. However, data anonymization is not so cut and dry under the GDPR. In fact, among the member states, there are differing interpretations of what qualifies as anonymized or de-identified data. So at what point is the data truly rendered permanently anonymous? Well, the GDPR doesn't specifically say. However, to determine whether the person is identifiable, you have to consider the costs, time required, and the available technology to determine whether there is any possibility that the data may be re-identified. Now, there's a second classification of data under the GDPR that's really important for us to touch on, and it's pseudonymized data. Commonly, we see pseudonymization with health data processing, where a number is assigned to a health record or a user profile to kind of hide the person's identity. Generally, the GDPR does apply to pseudonymized data. So if you are just using that function, then we will need to talk a little bit more about how pseudonymized data is regulated additionally. Now, why is this differentiation important to you as a digital health company? Article 9 of the GDPR discusses special categories of data. Specific to our purposes, these categories include healthcare and genetic data, as well as biometric data that are key to digital health innovation. To process this data, you have to have a legal basis to justify manipulating that data because it's highly sensitive to the individual. Next slide, please. This is important because increasingly countries are beginning to restrict the cross-border transfer of highly sensitive data unless it is completely anonymized. Remember back, anonymization is a very hard standard to meet. However, the classification of data as anonymized or pseudonymized also tends to be a spectrum, meaning that data will need to be analyzed on a case-by-case basis to determine how a cross-border transfer can be effectuated. This can create friction among potential EU customers if your company is exclusively located in the United States, and could even necessitate that you establish databases within various EU countries in order to effectuate those transfers and build your business. Traditionally, companies can't engage in cross-border transfers unless there are adequate assurances that are provided by the parties and the countries involved. Many countries have implemented GDPR data protection methods, and the two most frequently used are adequacy decisions and standard contractual clauses. A case passed down in July of 2020 called the Schrems II decision invalidated the adequacy decision between the EU and the US. So this means that the EU does not feel that the US has an adequate privacy regime to protect data transferred from the EU to the US. Today, however, I want to focus on standard contractual clauses. Before the Schrems II decision, controllers and processors were allowed to use standard contractual clauses to effectuate transfers exclusively. Next slide, please. In June of 2021, the European Data Privacy Board released modernized standard contractual clauses to be used by controllers and processors who are engaging in onward transfers of data. Here are a few issues to take note of. First, the clauses contained within the new standard contractual clauses are compulsory, meaning that they are required. They are also relatively onerous compared to the prior standard contractual clauses. The clauses cannot be modified to alter the regulatory obligations of the data controller or the data processor. They can only be expanded or included as part of a broader contractual agreement between four combinations of controller and processor relationships. This looks like a controller to controller relationship, a controller to processor relationship, so forth and so on. These contracts may look like data processing agreements, a customer agreement, or some other contract setting forth the data processing relationship. You must also be aware that Italy, Germany, and Spain have additional contractual requirements to engage in cross-border transfers of data relating to their citizens. In our experience at Nixon Gwilt, contracting for cross-border or onward transfers establishes a number of obligations that digital health clients find stifling to innovation, quite frankly, and their business model. However, it is important that these relationships be established in a compliant manner to avoid risk later. Some important dates to remember as well. As of September 27th of this year, 2021, all new data transfer contracts that you put in place that are governed by the GDPR must incorporate the new standard contractual clauses. We recommend that you reach out to us if you're entering into such a new contract so that we can ensure that you are properly incorporating the standard contractual clause language. Also, as of December 27th, 2022, all prior contracts, current contracts that you have, must be updated to either amend or migrate the old standard contractual clauses to the new standard contractual clauses. Next slide, please. So what else do you need to do next? Well, we recommend a number of action items for you to consider. First, we recommend that those currently engaged in business or planning to conduct business in the EU update your internal policies and procedures, as well as any external notices you have about how you manage, share, or store data. These policies should clearly reflect how you process data and for what purpose. The GDPR also requires that data subjects be informed of their rights, and those things should be included as part of your external facing notices. You should also conclusively identify the jurisdictions where you will obtain or process data. As mentioned previously, states are increasingly developing their own rules for processing and transferring data. This could substantially affect your ability to conduct business. You should also establish a data map to demonstrate how the data flows throughout your business. You should continue to maintain a data inventory even after this initial data map has been developed. In the instance of a breach, you have 72 hours to provide certain information to the supervisory authority governing your processing of the data. Having a data map can cull panic in moments such as this. Even when there isn't a breach, having a map can help you demonstrate compliance. Establishing a legal basis for the transfer of data goes hand in hand with data mapping and compliant contracting. Depending on what type of data you process and your role, your responsibility to obtain consent from the data subject may change. As to number 5, data security is a critical component of GDPR compliance. The focus of the law is to protect data subject information. With increased risk for data breach, it is important that you encrypt, pseudonymize, or anonymize data. It may even alleviate your compliance burden. Finally, you must enter into compliant contracts when transferring data across borders. Unless and until the EU feels confident that the United States has implemented adequate privacy safeguards, complying with the standard contractual clauses can make or break your business here and abroad. However, don't just copy and paste them into your contracts. You will need a tailored approach based on where you intend to do business or obtain your data. Next slide, please. Now, I understand the GDPR can seem daunting, and quite frankly, it is in many respects. Much like the digital health industry, the GDPR is still developing. However, the risks of noncompliance can be dire. Not only is enforcement by supervisory authorities picking up by way of serious fines, the GDPR allows for causes of action by private citizens for damages, and they can force your business to stop processing personal data. This can result in serious costs on the back end. As I mentioned before, entities who experience breaches have 72 hours to provide very specific information to supervisory authorities. You may also face costs of breach notification, and you may also have your business completely shut down. Having an effective program in place can help save you time and money. In addition to avoiding costly consequences, being GDPR compliant can come with some lucrative rewards. In our experience, as Bethany mentioned, having a GDPR compliant operation can expedite the deal-making process, whether that comes in the form of diligence or sales contracting. Having these measures in place can make building your business that much simpler. Now I'm going to turn it back to Bethany for a discussion on privacy documents, but we will be taking questions at the end. So please feel free to drop any of your GDPR questions in the chat, and I will try to address those at the end.
Yeah, as Ashley said, this is a great time to get her GDPR expertise. So if you have questions related to that, I highly recommend the chat function. So we've talked about the 3 most common privacy concerns that we see for digital health companies, right? We talked about HIPAA, how HIPAA grew from, what Congress passed in 1996 to the HIPAA privacy rule to now all the types of, compliance that you have to do with state law to now GDPR. So we've seen this evolution of privacy law in healthcare, and it naturally raises the question of how can you begin to build a privacy structure that is actually going to comply with federal and state privacy laws? So the starting point that we really recommend is developing comprehensive, clear, and accurate privacy documentation. And by privacy documentation, what I mean is privacy notices, privacy policies, and privacy procedures at a minimum that are going to fit within the scope of your organization. So notices, policies, and procedures are really going to be an essential component of your organization's compliance program. And personally, I consider them to be the foundation of the privacy framework that you're actually working to build. Now, these 3 documents are considered must-haves pretty much for any digital health company, regardless of whether you're in the startup phases or you're more advanced and you've secured funding versus you're, a nationally known healthcare company. All kinds of companies will need this documentation. And it's really because it explains to consumers and employees how you're going to handle sensitive health data. Now, a lot of times, whenever you're Googling these terms or you're listening to other webinars, other training opportunities too, you'll hear these terms used interchangeably, but each term actually has its own distinct meaning. So I just want to take a moment to try to explain to you the differences between each of these 3 documents, since they can seem to blur together a bit. So a privacy notice is an externally facing document that notifies your customers, your consumers, your users about your data privacy practices. So typically you will post the privacy notice on your website or on your app, and you'll require that users consent to the privacy notice before they can actually use your product. The privacy notice is functioning as a way to explain to consumers how your company is going to use the data that you collect, what kind of data you're actually going to collect, to whom you might later disclose that data downstream, and what rights consumers have in that data. So for example, do they have the right to request deletion or modification of that data? Now, if we look at a privacy policy in contrast, that is an internally facing document that explains your privacy practices and procedures to your employees or other vendors who might work with you. So a policy is essentially an organization's position on a particular topic. Companies and consumers will often get the terms privacy policy and privacy notice confused. So it's really not uncommon to hear an organization refer to both their internal and their externally facing documents, both as privacy policies. So don't get confused if you see on a website somebody's externally facing privacy policy. That is in fact a privacy notice, just with the terminology being combined. Finally, a privacy procedure offers instruction to employees on how to obtain the organization's privacy policy objectives. So procedures are typically going to set forth the steps that an organization, their employees or their vendors should be taking, and the process that they need to follow to make sure that you're addressing privacy concerns. So if there's an accidental disclosure of somebody's data, what are the steps that you should take to remedy that? If you have a data breach, how does that need to be responded to? Who should be notified first? What should be the action plan? When do we notify consumers? All of those kind of detailed step-by-step instructions, that's what's going to be in your privacy procedures. And the most common example is going to be the data breach protection procedures that a lot of companies have that specifically lays out what needs to happen in the event of a data breach internally to make sure that it is stopped, remedied, data segregated, et cetera. Next slide, please. So privacy notices, policies, and procedures are going to be unique to each organization, and there's not going to be a one-size-fits-all privacy document. And the reason that these documents are so unique to your organization is because they're going to be driven in large part by how you collect and use personal data. So your app or your device is going to collect or use personal data much differently than another app or another device. So this is why privacy notices, policies, procedures, all of those have to be specifically tailored to your particular organization. And that's also why, as Ashley mentioned a little earlier, you can't just copy and paste another company's documents and use them as your own and assume that they're going to work for your organization. I can't tell you how many times clients have come to me and said that, they have a privacy notice and they copied it from their competitor, and, their competitor does something very similar to them. And so they thought that document was going to be acceptable for their uses. That's very problematic because your privacy notice has to accurately and clearly tell your consumers how you're using, disclosing, and sharing their data. So if you copy a competitor's policy, but your data usage and disclosure practices are slightly different, you could then be subject to a state AG or FTC investigation. So the FTC is actually starting to crack down on deceptive practices for digital health companies. And that includes looking at privacy notices and making sure that they don't misrepresent how data is being used or disclosed. So when you prepare your privacy notices, policies, and procedures, it's really crucial to think about the data lifecycle of your product. At what points during the lifecycle are you collecting, maintaining, storing, using, or disclosing personal health data? At each point, right? How are you collecting it? Where are you storing it? How are you using it? To whom are you disclosing it? How are you safeguarding it? Who can access that data? When is data deleted? How can consumers request deletion, right? All of those are key questions that are tailored to your organization and that have to be answered specific to your company. And Ashley, I don't know if you have any other substantive tips before I get into stylistic drafting tips, but wanted to open it for any thoughts that you have as you've drafted these documents.
I do. And I think it's critically important to note that specifically for those of our viewers who develop apps, that privacy documents are critically important to the Apple App Store and Google Play, as well as any Facebook integration or other social media integration you might have on your app. Because the regulatory landscape and enforcement actions are beginning to rapidly increase, large organizations like Facebook, like Apple, have taken a closer look at the interplay between smaller companies and how their company functions. So in our experience, we've had a number of clients submit things to Facebook. Maybe they have a way to create an account directly from Facebook, and it's been kicked back because Facebook did not think that they were adequately describing their privacy practices. Also, we've had multiple apps be submitted to the Apple App Store, and they are concerned about the way that the data collection is described in all of their documentation as well as internally. So these are important considerations for you, again, to make sure that you're not using some prefabbed language. It needs to be very specific to your purposes, and we can help you develop that.
Wonderful. Thanks, Ashley. Next slide, please. So finally, in addition to the substantive aspects of privacy document drafting that we just discussed, you should really take time, if you're drafting these documents, to make sure that you're conforming to best practices that can be used whenever you draft these types of crucial, both external and internally facing documents. So first, make the writing style simple and please use plain English. So you should really be distilling the key relevant privacy concepts into a very easy to understand narrative so that people who might not be familiar with the technical language of the law or your platform, so that they can understand it. So that means avoiding legalese, acronyms, jargons, lingos, et cetera, that's not going to be commonly understood by everyone who is in your audience. Second, make sure that you use active voice. Active voice is so much easier to read and understand, and it also emphasizes the reader's responsibilities, whereas passive voice typically doesn't focus on the actor herself. And this is really important because you want to stress the actions and the responsibilities of your audience. Third, try to think of where your policy or your procedure can add value. So the purpose of a policy or procedure is not just to recite or recycle the legal rule that you're trying to follow, right? People can look that up online without having to go to you for your particular policies and procedures. And that's not really adding value. Where you want to add value is consider your position, your organization's position on the topic, or the correct procedures that you want your personnel to follow if a particular incident happens. So for example, you could consider explicitly describing the actions and the steps that you'd like your audience to take when they are faced with a request to use, exchange, or disclose healthcare data. Finally, policies and procedures should include examples of preferred and incorrect behaviors. So remember, the goal here of your policies and your procedures is not only to set forth the required actions, but also to provide an easy to understand and easy to follow guide. Examples are really crucial in helping to make sure that employees and your customers understand how they can take certain actions and what those preferred actions are. Next slide. Okay, so this concludes our substantive discussion here on the top 3 privacy concerns for digital health innovators. And we're really excited to help you build and strengthen your privacy compliance framework. So if you want any type of assistance with drafting your privacy notices, policies, and procedures, trying to determine how to comply or whether you need to comply with certain federal and state laws, or any other general privacy questions you might have, we really hope that you'll reach out. I've included our contact information again here. And we also have a very exciting new offering that we wanted to talk to you about today as well. It's called the Digital Health Privacy Exposure Audit. And here we would do a high-level review of your organization's privacy structure. We would identify high-risk, medium-risk, and low-risk privacy concerns. And then we would help you develop some strategies for resolution and risk mitigation. So if you're interested in this offering, I've included the link here as well. Please reach out. We can give you additional details. And at this time, I believe we're going to open the floor to audience questions. So next slide, please.
Awesome. All right. Thank you, Bethany and Ashley. That was really great. I think I even learned quite a bit during that. So thank you both for all of the very helpful information. We have a couple of questions both in the Q&A and then a couple that came in before the webinar. So I'm going to just ask these of both of you, and then whoever feels right to answer, go ahead and answer. And I will let you know if I think one question is more appropriate for one or the other. So one of the first questions that we got that I actually think, Bethany, you could start by answering, and then Ashley, it sounds like you might have some good expertise here as well. If you pursued voluntary HIPAA compliance even before it applied to your startup, could you hold on state level compliance until you actually become a covered entity or a business associate?
Yeah, that is a great question. Usually we see it the opposite way, right? We see companies who want to focus on getting in compliance with their state laws because they are not a HIPAA covered entity. And so the thing to think about there, right, is sometimes state laws can have more stringent regulations and requirements than HIPAA. So even if you're compliant with HIPAA, you would actually still need to comply with the more stringent aspects of the state law. The other thing to consider, right, is how is that, like, there are instances in which the state law will exempt you from compliance if you're regulated as a HIPAA covered entity. So I would look at that as well and try to determine, can you fit within any kind of exceptions to the state law because you're pursuing voluntary HIPAA compliance? If so, right, maybe you don't need to focus on any more compliance with respect to state law, but other times what you're going to find is, right, you have to actually be a covered entity or other, covered HIPAA, covered entity under HIPAA for that exception to apply. And so you might not be able to fall within that exception, in which case you would still need to make sure that you're complying with state law. So I do think that there are instances in which HIPAA compliance is a phenomenal starting point, and depending on the state law, right, there may be nothing more for you to do under that state law. But some states like California have a lot of stringent privacy requirements. And so there's going to be instances in which both a HIPAA covered entity would still have to comply with HIPAA and state law. And you would have to do the same if you're looking to have a voluntary HIPAA framework. And Ashley, I'll turn it over to you for any additional thoughts.
I do have a few thoughts. Amanda, thanks so much for your question. I really appreciate it. I think it's important for you to note that in addition to HIPAA compliance in a general sense, there are also certain things that specifically in California, all people have to comply with. So it's important to reach out to an attorney and talk with them a little bit about what states you're really targeting. Do they have rules that may impact your business model, especially if you are obtaining medical records? What kinds of rules and regulations are there surrounding keeping those and releasing them to patients? But also, what needs to go in your privacy notice as a baseline level of compliance. And that is something that I recommend that you establish very early so you don't have to worry about it later on.
Yeah. And you may also just want to think about the long-term goals for your company, right? If you are a startup digital health company right now who's never going to work with covered entities and never going to work or never going to become a covered entity, then you're probably never going to be subject to HIPAA, but you may very well become subject to state law in the future. So if your long-term goal is to really get a lot of users in a state like California, and you're going to end up being subject to CCPA anyway, you may want to just focus on CCPA for now and not worry about HIPAA. But on the flip side, right, if you are going to be a covered entity one day, or if you are going to target hospitals or health systems or healthcare providers as customers, you may end up becoming subject to HIPAA. So maybe at that point, it does make sense to start now by looking at HIPAA. So I think that's another piece that you may want to think about when you're determining what your privacy structure should look like as an early stage startup is what are your long-term goals and where are you headed and how do you get a head start now that's not going to break your budget? Okay, one more question in the Q&A also from Amanda. What are typical elements of a company's privacy budget? Legal, technical engineering, other, and what team typically drives and maintains your privacy framework?
So I want to touch on the second part of your question about which team typically drives and maintains privacy framework. So increasingly, we are seeing instances where, for example, the GDPR requires you to have in place a data protection officer. That is really something that we recommend for even our early stage companies, having somebody who is specifically responsible for understanding how data is obtained, how it's stored, how it's shared, so that if you have any issues, that person is the go-to. As far as not being required to have a data protection officer under the law, we still recommend it because we are seeing a lot of big corporations ask, well, who is responsible for your data privacy regime? In that instance, it's easy to say, oh, Amanda is responsible for it. She is our data protection officer. She understands the ins and outs of this field, and she can answer any questions that you may have. As far as your privacy budget, again, as Caitlin mentioned, I think that plays in a little bit with where you are in the development of your business and what your goals are for the future. If you are trying to rapidly ramp up your user base, then I would recommend putting a little bit more money into determining the law. I know you asked about legal, determining where there are laws that are going to apply to you and how you need to set things up so that you are compliant in the future. But also the technical and engineering piece is very important from a security standpoint, because you can't respect people's privacy if you don't have certain security measures in place. So that is a way to say that I think it is important to balance these considerations depending on how many users you anticipate serving and where you anticipate you're going to get your data. And some additional considerations: are you going to be selling data, monetizing data? Are you going to be sharing data without monetization? Are you going to be working on a schedule of data deletion and establishing those kinds of parameters within your company?
Yeah, I would really echo what Ashley said about balance. So a lot of times, if you're in the very early stages of a startup company, you're not going to have a privacy professional on your team, right? Those companies, a lot of them are being built out of people's homes. There's 1 or 2 employees. You're trying to get a company off the ground. And so oftentimes there, you're more focused on the product. And so I think any kind of privacy, emphasis and budget at that point goes into looking at how you want your device to be structured, how you want the privacy to be handled within the device. Are you using privacy enhancing technology, right? Are you incorporating privacy by design at that stage? And then we see typically as companies get a little bit more funding and they're trying to secure more of those deals, that's when they start to look at their privacy structure more in terms of a legal sense and like, how do I need to present, the privacy notice here? I'm getting more companies. I'm contracting with more vendors, what do my contracts need to say about how we're handling data privacy? I have employees now, how should they be handling it? What is this minimum use rule, right, in terms of how much data they have access to? So that's when we typically see more of the legal side come into play. You still have to worry about, right, the system and the structures and making sure that you have things built so that it's privacy compliant and protecting users' data and their security. But at the same time, the legal aspects are really important, because as you grow, you've got to add more components into your privacy compliance framework. It's not just the documents. Then it's training your employees, right? It's getting a privacy compliance officer onboarded and trained. It's making sure that you have security protocols in place. So privacy from a legal perspective really starts to ramp up as you grow.
Great. Yeah. And I will just touch on the first part of your question, Amanda, about the typical elements of your privacy budget. So legal and technical are definitely great places to start. I might also consider broadening out that legal category to professional services, because there are also third parties that can help you do a SOC 2 audit if you get to that point under HIPAA, or do other types of audits of your privacy practices and your security practices. So sometimes that legal category gets broadened out into other professional services. And then one other area that I can think of off the top of my head is insurance. If you are handling sensitive data, you're going to want to have really good insurance coverage in place in the event that you experience a breach or anything else happens. Also, most of your customers, if you're working in the B2B space, are going to require it anyway. So that would just be a third category I would think about, especially at an earlier stage, is having that insurance in place as well. Right. So now I'm going to move over to the questions that came in beforehand. We're at 3:01. Let me try to get one more question in very quickly. Ashley, if a startup is not doing business in the EU and does not ever intend to, do they need to put GDPR privacy measures in place?
Sorry, it would help if I would hit unmute. So it can't ever hurt to put in additional privacy measures, but that doesn't need to be an arduous process. At minimum, you should really consider beefing up the transparency that you put into your user-facing documents around how you process the data. Make sure that those documents are consistently updated in the instance that you maybe change your processes even a little bit. And then also establish a process for addressing a breach with the internal policies and procedures, as well as something that's external facing. You could also, again, as we mentioned previously, designate a person to serve as your data protection officer. And this person really will be your point of contact. It will be the backbone of your organization to help you develop your company in a compliant manner, but also to really beef up the measures that you're taking in order to protect outside user data. In the instance that you ever do interact with EU data subjects, if you've already got these things in place, it's going to be a lot less of a pull to get there if you do have to follow more of the arduous requirements.
Got it. So maybe look to some of the foundational pillars of GDPR as kind of a best practice, but not necessarily worrying about the nitty-gritty details and the nuance when you're early stage.
Right. And the nuance is quite significant with GDPR, but I think it's also important for everybody to remember state laws are beginning to implement privacy practices that very much mimic the GDPR. So if you are staying up to date with state law, you're well on your way to GDPR compliance, if that's how you choose to expand. And again, internationally, lots of countries are looking to the GDPR as a guide for how to build out their own privacy protections. Specifically, Brazil just implemented an identical body of law to the GDPR. So this has broader implications, but if you want to start building that kind of a program, it cannot hurt.
Awesome. All right. Thank you all so much again for being here. Like I said at the beginning, this has been recorded, so keep an eye out in your email inboxes for the link to the recording. We will also be posting this on our website, so you will be able to access it later. And then as always, reach out to Ashley and or Bethany if you have follow-up questions, and they will be happy to answer those for you. Thanks, everyone.
And if you're looking for up-to-date privacy and cybersecurity information, please also feel free to connect with us on LinkedIn, and you'll get some great content there as well.
Perfect. All right. Bye, everyone.
Thanks so much.
Thanks.